Hi, I'm Zach Rosenberg, and I will be on the negative side of the resolution. The U.S. federal government should heavily regulate internet pornography. There is no need for heavier regulations on internet pornography in the United States. Pornography is protected by the First Amendment, as is shown by the court cases Reno v. ACLU in 1996 and Ashcroft v. ACLU in 2003. In Reno v. ACLU, the American Civil Liberties Union, several litigants challenged the constitutionality of two provisions in the 1996 Communications Decency Act. Intended to protect minors from unsuitable internet material, the act criminalized the intentional transmission of obscene or indecent messages, as well as the transmission of information which depicts or describes sexual or excretory activities or organs in a manner deemed offensive by community standards. After being enjoined by the District Court from enforcing the above provisions, Attorney General Janet Reno appealed directly to the Supreme Court as provided for by the Act's special review provisions. The court case had a unanimous decision in favor of the ACLU. In Ashcroft v. ACLU, Congress passed the Child Online Protection Act, known as COPA, to prevent minors from accessing pornography online. The ACLU and online publishers sued in federal court to prevent enforcement of the act, arguing that it violated the Free Speech Clause of the First Amendment. The District Court agreed. On appeal, the Third Circuit Court of Appeals panel affirmed, holding that because the act used community standards to decide which material was harmful to minors, it would prohibit material that was felt offensive in the most puritanical communities from being displayed in more tolerant ones. On appeal, the Supreme Court ruled that the community standards provision alone did not make the act unconstitutional and sent the case back to the Third Circuit for further evaluation. The Third Circuit again prohibited implementation of the act, holding that it was likely to fail the strict scrutiny test because it was not narrowly tailored. That is, it prevented online publishers from publishing some material that adults had a right to access, and because it did not use the least restrictive means possible to protect children, the court found that blocking software installed on home computers by parents would do as good a job without preventing free speech. For similar reasons, the panel found that the act was unconstitutionally overbroad. That is, it applied too much protected material. My plan is to keep the standards for regulating internet pornography as they are. This standard uses what is known as the Miller test. It is a three-pronged test that was established in Miller v. California in 1973 for judging obscenity. The three tests for this are as follows. 1. Whether the average person applying contemporary community standards would find that the work, taken as a whole, appeals to the prurient interest. 2. Whether the work depicts or describes, in a patently offensive way, sexual conduct specifically defined by applicable state law. 3. Whether the work, taken as a whole, lacks serious literary, artistic, political, or scientific value. The combination of standards set by the community and standards set by the rest of the nation in the Miller test allow for a variety of opinions to decide whether or not certain material should be readily available. Finally, I would like to bring up a procedural issue. The positive's video exceeded the given time parameters of his speech. I would therefore like to discredit any pieces of information given after the exceeded time limit.